An oversight hearing to hear testimony from the Department of Education's implementation of the Borrower Defense Rule. Pursuant to Committee Rule 7C, opening statements are limited to the chair and ranking member. This allows us to hear from our witnesses sooner and provides all members with adequate time to ask questions. I'd like to thank Secretary DeVos for being with us today and thank her for agreeing to hold enough time in her schedule to allow all of the members present to ask 5 minutes of questions pursuant to House rules. And I'm especially thankful because as chair, I'm exercising my prerogative to go last in the question order. And so if she were to leave early, I wouldn't get to ask questions. So thank you for agreeing to stay with us for the full time. I recognize myself now for the purpose of making an opening statement. We're here to examine the Department of Education's implementation of the Borrower Defense Rule, and I want to thank you, Madam Secretary, for appearing before the committee to discuss this important issue. The Borrower Defense Rule is grounded in basic fairness. Student borrowers who are defrauded by their college face severe financial and emotional consequences, and it is therefore cruel and counterproductive for the federal government to compound their misfortune by collecting on their student loans. Accordingly, the Higher Education Act requires the Secretary of Education to provide debt relief to defrauded borrowers. Until recently, that authority was rarely needed because institutional fraud was uncommon. But in 2015, Corinthian Colleges, a large for-profit chain, abruptly closed its doors in the face of widespread allegations of fraud. Those allegations were later substantiated with countless reports of schools luring students with false promises of guaranteed jobs upon graduation and inaccurate information about the transferability of credits. A year later, another for-profit chain, ITT Tech, closed under similar circumstances. In response to a surge of claims, the Obama administration issued a new borrower's defense rule to streamline the process for providing relief to defrauded students. By the time the Trump administration took office, 28,000 Corinthian students had already received relief, and the department was on pace to process the remaining 54,000 pending claims by the spring of 2017. However, under the present leadership, the department has refused to implement the Borrower Defense Rule. Instead of providing defrauded borrowers with full and timely relief, as the law allows, the department halted processing claims so that it could invent a new formula that ensured most defrauded borrowers would get only a fraction of relief that they were eligible to receive. The department's initial partial relief formula would have deprived about 93% of defrauded students full relief. In 2018, the federal court blocked the initial partial relief formula because it misused students' personal data. But even after the court's ruling, which specifically asserted the department could provide timely and full relief to eligible borrowers under the Obama-era framework, the department refused to do so. In fact, in 18 months between the court's June 2018 ruling and today's announcement of a new revised partial relief formula, the department did not process a single borrower defense claim. Meanwhile, the victims of predatory schools are being left in limbo. The number of borrowers awaiting relief has grown from 54,000 to roughly 240,000. So, Madam Secretary, your refusal to process claims is inflicting serious harm on students that you have the duty to serve, while the department has been searching for a legal method to shortchange these defrauded borrowers. These defrauded borrowers have been left with mountains of debt, worthless degrees, and none of the job opportunities they were promised. In many cases, they were unable to go back to school, start a family, or move on with their lives. And not only has the department refused to provide relief to defrauded students, it also illegally collected on 45,000 borrowers who are waiting you to take action on their claims. In some cases, these individuals had wages and tax returns garnished by the very government that was supposed to be providing them relief. The court found you in contempt of court for collecting on roughly 16,000 of these borrowers, but now the department has conceded that it was illegally collecting on about 45,000 borrowers. In some, the defrauded borrowers have been cheated twice, first by their college, then by the Department of Education that refused to make them whole. In court filings, the department admitted to gross negligence in handling the Borrower's Defense Rule. Throughout the last year, this committee has sent multiple requests for information and documents in an attempt to understand the rationale for changing the department's policy. The department has continually refused to comply with those requests. This lack of transparency was in full display yesterday when a media outlet published documents revealing that the department's own staff conducted an extensive review of claims from former Corinthian and ITT Tech students and found that student borrowers who attended these schools deserved full debt relief. Those memos should have been provided to the committee in response to our repeated requests. Their existence raises, unfortunately, two important questions. One, why was there a refusal to provide relief and immediate debt relief to defrauded borrowers despite the clear finding of the department staff? And two, are there other relevant documents in the department that the department is withholding from the committee and the public that would shed light on policy decisions? Today's hearing is intended to get answers to these and other questions about the department's policy on behalf of roughly 240,000 borrowers awaiting relief. So thank you again for joining us today, and I yield now to the ranking. And I recognize myself for 5 minutes. First, a lot has been said about whether or not this applies to for-profits, private, nonprofits, or public. The fact is we have several 100,000 complaints of fraud for Borrowers Defense for the public colleges. How many public, nonprofit, and public institutions have been subject to allegations of fraud?
How many? I don't have the specific breakdown here. I'd be happy to get back with you.
Do you have
on a question for the record?
Do you have very many complaints from public colleges?
There are quite a few. I mean, it's frankly surprising the number of claims that have been filed from like surprising institutions. So
you've also indicated that you've remediated the credit report problem.
yes, we've remediated the problems that occurred.
Does remediate mean you've corrected the credit reports, or that you've reimbursed people for loss of job or higher interest rates they might pay? Or did you just correct the reports?
Whatever the issue was, we have remediated for, with the small exception of those whose addresses we can't track down.
Does that mean you've corrected the reports or compensated people for lost jobs or higher interest rate they may have paid for a diminished credit report?
We have corrected or remediated their credit reports if it's a specific credit report question.
Are you aware that the University of Phoenix recently agreed to a $191 million settlement?
I understand that, and I also understand that the leadership there are formerly lead employees, political appointees of the Obama administration.
That's fine. How many did that settlement involve federal student loans?
I imagine that there are some federal student loans involved there.
Were any federal student loans involved in the settlement?
General Brown?
Have there been, excuse me, General Brown?
Not that I'm aware of. Or
there are requests for borrowers' defense from the University of Phoenix. About 8,000, is that right?
Right now, today, we have 14,000 of those borrower defense claims are from the University of Phoenix.
Okay, what is the status of those?
Those applications are in various stages depending on when they were received.
Has any relief been granted?
I do not believe that. I can get that for the record and provide it for you, sir.
Okay, now as I understand it, if you've been defrauded, you should get relief if you have suffered financial harm. And we've had back and forth about how you establish financial harm. If you have two similar schools and you have your comparison group where they did not lie and cheat and defraud the students, they just acknowledged that the credits weren't transferable and you weren't going to get a job, but people went anyway. And you have another school that in fact defrauded the students, lied to them about accreditation, lied to them about transferability, and lied to them about job placements. Is it true under your formula you'd get no relief because you don't show financial harm?
Mr. Chairman, the methodology looks at all programs across the country that are like programs to the one that the borrower is making the claim against.
Right. And if the one you're making a claim against, in fact, defrauded the students, where the comparison group did not lie about the placement rate, didn't lie about accreditation, didn't lie about transferability of credits, and ended up with the same income as the one that in fact defrauded the students. Is it true that under your formula, the students that were defrauded get no relief?
If there is no financial harm to that to the student making the claim, that would be correct.
Okay. And is it, I think we established that there's no individualized consideration. It's considered by class. If you went to that college, if you make a lot of money or you didn't make any money, you'd get exactly the same relief.
The claim is against the student debt against that school and program.
Okay. Can you briefly describe what the department admitted to when it admitted to gross negligence in the lawsuit that provoked the contempt of court?
Well, I think those are attorney's words. What we have acknowledged.
The department
What we have
admitted
acknowledged is
gross
that there were human errors made at federal student aid and with our student loan servicers, and that we acknowledge them, we take responsibility for them, and we have corrected them.
Defendants respectfully submit that the department's compliance report undersigned counsel's representation in the October 7 hearing, and the further information contained in this brief established that compliance errors at issue here were not the result of any willful or intentional conduct, but, as the court has recognized, gross negligence, including negligent oversight of the department servicers. My time has expired in 19 days. I just want to say, and finally, there's no question of whether partial relief is available or not, but in some of these cases, the fraud was so widespread, and the findings of the previous administration was that some of these degrees were absolutely worthless. University of Phoenix had a $191 million settlement for fraud. Nothing has been done so far on federal loans to provide that relief. We would think that if the fraud has been well established, that each person wouldn't have to come up individually to prove individual fraud. If there's such widespread fraud, I think the burden ought to shift to the business. And finally, a lot has been said about the Obama process. The memos that we have presented show that there was a process. They discharged loans for 28,000 borrowers and had a process that would have eliminated the backlog in a couple of months. As I indicated, we hadn't seen it. Obviously, we'd seen it. We hadn't seen them in the submissions, but we got those memos showing the process from the media, not from submissions. So we'd expect if we had gotten those earlier, we could have discussed them not as gotcha, but as part of the process. There's no further business to come before the committee. Without objection, the committee stands adjourned.